Good afternoon, everyone. This is the final church and tax exempt entity webinar for 2024. This is the ninth in our series, live from the Carpenter Law Firm studios here in our office in Gilbert, Arizona. This is an Arizona-based law seminar. We're going to talk about the 2024 year in review. It's been an eventful year for legal issues for churches and nonprofits. And we're going to kind of start at the top when we talk about the legal issues that have been confronted. We always think about the U.S. Supreme Court and what it has been doing for religious freedom and the First Amendment, the free exercise of religion. And 2024 was not a particularly eventful year. When you think about the Supreme Court, what we're reminded of is that the Supreme Court meets in a session that roughly approximates the academic year. It starts in the fall and it ends in the spring, and roughly ends its term in June of each year, leaving its most controversial opinions, decisions in court cases for June of each year. And as it turns out, there were no controversial religious freedom, free exercise decisions in calendar year 2024. So by way of reminder, there were a couple of decisions in June of 2023, which we did not cover in detail in any of our 2024 church law seminars. So we'll quickly remember those in our 2024 year in review. One of the more important ones was a case that we refer to as 303 Creative LLC. This was a Colorado case. It started in the state of Colorado, where the state of Colorado, through a state regulatory agency, required all businesses in Arizona to be non-discriminatory in the way that it provides goods and services to the citizens of Colorado. And in the 303 Creative case, which got a good bit of press at the time and leading up to the Supreme Court's decision, the owner of the wedding website company refused to create a wedding website for a same-sex wedding. And the U.S. Supreme Court case in 303 Creative held that the owner of this wedding website company was not obligated to create a wedding website for the same-sex couple for the same-sex wedding. So obviously this was an important religious freedom case, that the owner of the business was not obligated to provide business services in furtherance of the same-sex wedding. Could have been the wedding cake, could have been the wedding website, any services in furtherance of the same-sex wedding. In the same month, there was another case, Groff v. DeJoy, where the United States Postal Service had been attempting to force a postal employee to work on Sunday against this worker's desire to take Sunday off, to have a day of rest, attend church services. And the U.S. Supreme Court held that the employee was entitled to exercise his religious freedom to have that day of rest and to attend church services. So not necessarily a case that's important for churches per se, but an important religious freedom case. Again, from June 2023, we're doing a 2024 year in review, but these cases, of course, stand the test of time and are part of the law in the United States. So this is what we're dealing with from the U.S. Supreme Court. We always sort of start there when we talk about the state of the law. There are no similar cases making their way through the courts. As you know, of course, these are actual disputes between real litigants. They start in the trial courts, they go to the Court of Appeals, and they only end up in the Supreme Court because the litigants, the plaintiffs and the defendants, have not settled the case or have not become satisfied with the outcome, and they keep appealing. So we know well in advance, sometimes months, if not years in advance, the cases are making their journey to the US Supreme Court. We knew about the Dobbs case, the abortion case, years in advance of the US Supreme Court's decision. There was a lot of talk and press about the Dobbs case eventually ending up at the US Supreme Court. The case already had decisions at the Fifth Circuit Court of Appeals. There was a trial court decision. And there was talk about the Dobbs case ending up at the US Supreme Court well before it did. So we don't have very many similarly situated religious freedom cases that we know about that are on a journey to the US Supreme Court like these two that I've just discussed. All right. In addition, 2024 was another year where we have seen physical attacks on churches, whether it's assault, battery, items being thrown at churches, or arson, things like that. In 2023, the Family Research Council, an admittedly criticized organization, there were 436 acts of hostility in 2023 against churches. We can't count 2024 because it's not over yet. But in 2023, the last completed calendar year, 436 acts of hostility against churches, whether that's a burglary, arson, an attempt to burn down a church, something like that. This is a constant challenge for churches to make sure churches are secure. Campus safety is also an ongoing concern, making sure that attendees are safe while on campus. The old, that's why we have insurance is not an acceptable attitude. If something bad happens and we're sued over it, that's why we have insurance. I don't accept that. As a lawyer, you'd think, well, that's how lawyers make money. When there's a claim, lawyers get to defend their clients. I'm not that cynical. I've been a lawyer for a long time. I've seen a lot of bad things happen. Frankly, I've made money from these things. But the worst part is that when a bad thing happens, someone is a victim. Someone's been hurt, someone's died, and for an organization, whether it's a church or a school or a retail establishment, to say, well, a bad thing happened, but that's why we have insurance, is an unacceptable attitude. We have to guard against bad things happen. When we invite people onto our property, onto our campus, whether we're a grocery store or a school or a church or a law firm, any establishment, when we invite people on, we have an obligation to make that environment as safe as possible, whether it's the receptionist desk at a law firm or a church or school, grocery store, whatever it is. We have a duty under the law for it to be as safe as possible. To fall back on, well, that's why we have insurance, that's unacceptable. Now, you may think it's acceptable. You may think, well, that is why we have insurance. But the duty is for it to be safe. Someone was injured or died. The attitudinal response, that's why we have insurance, is really not okay. So we have to have a campus safety plan. I've been telling my church clients for 20 years, every church should have a safety officer in a yellow outfit with big block letters, 4-inch letters that says security on it. Everyone on campus should know on a Sunday morning who is the security officer, the security person. Forget about the word officer. Who is there to do security? Now, usually it's a police officer in real life, a retired police officer. There's someone in your church who will gladly, happily, and with some amount of joy, wear a shirt that says security. And it'll be yellow, green fluorescent. Kind of like I'm no Seattle Seahawks fan, but the fluorescent green Seattle Seahawks uniforms, or the Baylor Bears fluorescent uniforms, something like that. Something that says security, yellow, bright. You can't miss it. And not just to scare off the bad guys, but for someone on campus who's in distress for whatever reason. Maybe she's in distress because her ex-boyfriend, who is subject to an injunction against harassment, just showed up on campus. And she needs to tell somebody. She can't call 911 fast enough. She left her phone in her car. The car is at the end of the parking lot. Her ex-boyfriend just showed up on campus. He's in violation of an injunction against harassment. She needs to do something about it. But the officer in the yellow shirt that says security on it is her best option. But in your church, the security person is not obvious, not wearing a yellow shirt that says security on it. You just kind of have to know who it is. It's Bob. Everyone knows that Bob is the security officer. But does everyone know that Bob is the security officer? No, because not everyone's an insider. Not everyone knows because she's a visitor. She's only been there 2 weeks. And although you think everyone knows Bob is the security guy, she doesn't. She doesn't know about Bob. Now, Bob is a retired police officer, and Bob's been the security guy for 2 years. But she doesn't know that because Bob doesn't look the part. We need Bob to look the part. Although you think everyone knows Bob is the security guy, she doesn't know that. So we need to have a campus security plan. The most important part about the campus security plan is that people who come onto the campus can't miss it. It's not just orange cones in the parking lot that tell people how to get through the parking lot on Sunday morning. It's more than that. It's as I just described. For the woman who has an injunction against harassment against her ex-boyfriend, when he comes on campus, can she get help? Can she get help quickly? We're also worried about non-custodial parents. When the custodial parent drops the kids off with your child care scenario, and the non-custodial parent comes by an hour later, an hour and a half later, pastor took longer this week to get the message across. And the kid says, "Hey, Dad, glad you're here today. Daddy. How's your protocol on that? Are you going to release the child to the non-custodial parent when the kid says, 'Dad, I'm glad you're here'?" Because the dad brings the kid every other week. We've got issues with that in many churches. And then, of course, we still have our challenges with the duty to report statute here in Arizona. It's complicated. It's non-forgiving. The police and detectives who deal with the duty to report statute are unforgiving. They have high expectations. And one of the one of the greatest challenges we have is that many churches and pastors believe that they can ask their volunteers to report inside the church, and that's good enough. But the statute doesn't say that. Um, we may spend more time on the duty to report in a 2025 seminar, but the duty to report is an ongoing issue. And then, as I mentioned early in my earlier discussion about the yellow security officer, injunctions against harassment. Where does the church fit in when a woman has an injunction against harassment in place against her ex-boyfriend? Where can the church, how can the church navigate being in the middle of that mess? And it is a mess. And why did I say woman have an injunction against harassment against her ex-boyfriend? Well, statistically speaking, that's what it is. Most of the time, that's how it's structured. So we have these attacks on churches, the criminal attacks, but it really comes down to how can we protect our churches, and protecting our churches from these external attacks is often about campus safety plans, but really campus safety plans are also about protecting our attendees, and protecting our attendees morphs into what are we doing on Sunday morning? How are we protecting the people who attend, our visitors? And once we start talking about that, drill down to what is a campus safety plan. It's often about these police officers who attend our church, retired police officers. What are they doing? And then we drill into some of the things that actually come up on Sunday morning, non-custodial parents, the children, the duty to report, and some of the other things that actually happen with these injunctions against harassment. And now we're not even talking about these acts of hostility anymore. We're talking about campus safety plans and some of the outlines that really need to happen. That's what ends up happening as a lawyer for us here at the Carpenter Law Firm on our church law team, is we end up reviewing for some of our church clients their campus safety plan, looking for recommendations that we can make and holes that might exist. But in many cases, the real expertise is with the police officers that attend the church who are volunteering to be part of campus safety. That's where the real expertise is. Any police officer who's been a police officer for any number of years, or even a retired police officer, really has a lot of expertise. Put them on a campus safety committee, and before you know it, you're off to a great start on a campus safety plan. It's not just about putting up the orange cones and making sure the cars move through the parking lot correctly, although that's part of it. Really drilling into what are we doing to be responsive on Sunday morning, being visible on Sunday morning, and making sure everything is done in a safe manner for the people there, keeping the pastor safe as he moves around the campus is part of it, especially for some of the larger churches where the pastor has more visibility, things like that. All right. One of the things that's come up in 2024 that I want to mention briefly is Project 2025 and how it has impacted the way some churches are viewed here in 2024. I never expected that I'd talk about this as I was looking at my church seminar schedule for 2024. It's Project 2025. Of course, I had no idea what it was until people started talking about it. So what is it? Well, the foreword of Project 2025 contains this statement. Today, the left is threatening the tax-exempt status of churches and charities that reject woke progressivism. They will soon turn to Christian schools and clubs with the same totalitarian intent. So the authors of Project 2025 believed at the time of drafting and publishing Project 2025 that the left a sort of generic broad term. If in power, I suppose one could say, desire to take away the tax exempt status of churches and charities that reject the principles and beliefs of the left and uh, progressivism, liberalism, woke progressivism, as if it's some species of liberalism, and that the governing left liberalism, if it were to take power, would also include Christian schools and clubs with the intent to take over. So, as a governing perspective, um, I don't know that this statement is true. There has been some talk, maybe in the Twitter sphere, by some liberals, you want to call them that churches and tax exempt entities uh, shouldn't have a tax exemption. Now, remember, the tax exemption is two pronged. Talked about this a couple of seminars ago, that the income received by a tax exempt organization is tax free from the corporate tax, but also the donor does not pay income tax on the donation. We know this. This is the two pronged effect of being a tax exempt organization. I give money to my church. I deduct that amount from my taxable income on my personal taxes. And the organization that receives the money does not pay corporate income tax at the corporate level. And so, the criticism is twofold. Rich people should pay income tax on all of the money that I make in my total income. I should be taxed on everything, including the money I give to my church. I should not deduct that from my total taxable income. And the church receives the money, the church should pay corporate income tax on all the money received. Churches should pay corporate tax rates on all of the money. So when people advocate for removing the tax exempt status of churches and charities, they're talking about rich people no longer having a deduction from their taxes for money given to these organizations, and the organizations themselves paying corporate income taxes, just like Amazon or Tesla or whatever, that they should pay corporate tax rates, corporate taxes at corporate tax rates. So Project 25 has been a discussion in the public sphere because of things like this, because this is really a pretty serious accusation. It's not against any one person, it's an accusation in the political realm. So, regardless of whether the statement is true or false, uh, it, with the result of the recent election, the tax exemption doesn't appear to be threatened for the next 4 years based on the results of the election. We could say that with some sense of um, confidence. The rest of this Project 2025 document is noteworthy for the attention it's received in 2024. President Trump, then candidate Trump, disavowed it, but the authors were apparently close to him and now part of his inner circle. I have no view on that. I have nothing really to say about it other than that it's noteworthy for the attention it received. So the tax exemption is important to churches, although one thing about it that's interesting, which I've talked about before, the federal tax cuts that occurred in the first Trump administration included a provision that raised the standard deduction, the amount that people don't have to, that of wages that people make that they don't have to pay federal taxes on. It raised the standard deduction, which means that many people do not itemize their deductions. That's important because claiming a deduction for your charitable donations is an itemized deduction. By raising the standard deduction, Congress made it so that fewer and fewer people claim charitable deductions on their taxes, which is what this is all about. This tax exemption for churches and charities is a charitable deduction. Well, you only reduce your federal and state income taxes by making donations to charities and churches. It only impacts your taxes if you itemize your deductions. Itemizing your deductions is an alternate way to do your taxes than taking the standard deduction. So, a lot of people used to itemize their deductions. But when the Trump tax cuts increased the standard deduction so that fewer people would pay federal taxes based on the amount of income they have, fewer people started giving to charity because it didn't matter anymore because fewer people itemized their deductions. All right, here's another thing that's happened in 2024. There's an increased awareness of the term Christian nationalist. This has impacted churches. It's impacted a number of our church clients here at the Carpenter law firm. 2024 became the year of labels in the public sphere. If Democrats are woke liberals, then Republicans in some corners of the public sphere have become white Christian nationalists. Regardless of what these terms mean, and regardless of any proof on both sides, no denial is sufficient in the new courtroom of social media and public accusation and shaming. If you're a Democrat, you're a woke liberal. If you're a Republican, you're a white Christian nationalist. You could be purple. By race, you could be a purple person. But if you vote Republican, you're a white Christian nationalist. And you could be asleep and you could be a conservative, but if you vote Democrat, you're a woke liberal. Trying to make a joke there, woke, awake, sleep, conservative, liberal. But if you vote Democrat, you're a woke liberal. In the new courtroom of social media and public accusations and shaming. And of course, this is ridiculous on both sides. That if you dare to vote for a Democrat, you're a woke liberal. If you dare to vote for a Republican, you're a white Christian nationalist. So in 2024, these terms have become insults and smears. We live in a divided world, a divided country. And so this idea that if you're white and you're from a red state or vote a Republican, you're a white Christian nationalist. But also if you go to church, certainly you're a white Christian nationalist and you're a racist and you hate women, of course, and that's the smear. So if you're a pastor of a church, then you must be a white Christian nationalist. I mean, that's a heavy cross to bear. So what are the legal issues here? Well, there's defamation. It is defamatory to smear someone in an untruthful way. And to call someone a white Christian nationalist when they're not one, that's an insult. That is a defamation. It's not true. But here's the problem. I probably have 2 or 3 conversations a week about defamation with clients or potential clients. And the problem with defamation is that if it were the type of lawsuit endeavor for the lawyer that made sense, there would be lawyers with billboards all across the state advertising for clients to hire them for defamation. But there are not any billboards that I'm aware of where lawyers are saying, have you been defamed? Call me. And the reason is actually pretty simple. The reason there are so many billboards across the country for lawyers who want clients who've been injured in an accident is that there's insurance on the other side. And in car accident cases, the state requires everybody who operates a motor vehicle to have insurance. It's a good bet for the lawyer. The lawyer will take the case on contingency. I only get paid if we recover from the person who harmed you in the accident, because I know the person on the other side of the collision has insurance because it's mandated by statute. Every motorist every person who operates a motor vehicle has insurance because it's mandated by statute. But if not, you probably have uninsured motorist coverage on your own policy. It's a good bet for me to put up that billboard and spend a bunch of money on it, because if you've been injured in an accident, we're going to get some money from somewhere, either the other person's policy or your own policy, perhaps. The problem with defamation is when a random person calls you a white Christian nationalist and you're not a Christian nationalist and you're not even white, calling someone white when they're not, maybe that's an insult, maybe it isn't, but let's just say the whole thing is a defamation. Truth is a defense to defamation. So we're not even, let's just say it's false. You're not a white Christian nationalist. The person who said it may have insurance to pay for the legal fees to defend the defamation lawsuit, but they may not have insurance to pay the jury verdict. We call this insurance for defense costs versus insurance for indemnity. There's a difference. Some insurance pays legal fees for defense, but not indemnity, not the jury verdict, not the judgment. So in defamation, there are a number of there are a number of circumstances where you sue someone for defamation. They may have insurance that will hire them a lawyer to defend them along the way in the case, but they do not have insurance that will pay the jury verdict if they lose. So there are times when we have a good case for defamation, but the lawyer who brings the case for defamation is going to entertain a contingency only if there's insurance for that second piece, the jury verdict. Why would I partner with a client on a case if there's no insurance for the jury verdict part? I'm going to do all the work, I'm going to front all the effort in partnership with my client to get to the end. If I'm going to only get paid if we win, I've got to make sure that there's insurance for that indemnity piece, for that judgment piece at the end. If I'm going to take a contingency, if I'm going to take it on a contingency, I'm not so concerned that the defendant, the person we're suing, has insurance for the legal fees along the way. If I'm going to take it on contingency, I've got to know that there's insurance for the jury verdict part at the end, because that's the only way I'm going to get paid. So that's why there are no billboards for attorneys saying, have you been defamed? I only get paid if we win. That's the problem with defamation cases. So being called a white Christian nationalist has become the insult of the day, the insult du jour. But there's not much we can do about it that's easy, and there's no group of lawyers that meet for lunch once a quarter to talk about all of the defamation cases that we're suing about this problem. And there is no group of lawyers who are meeting once a quarter to sue people who are accusing their clients of being woke liberals either. Because in this social media and public square accusation and shaming world, the problem exists on both sides. So we're kind of in a world where there's not a whole lot that could be done, unfortunately, because it is a pretty significant problem. So churches have to operate in this challenging environment, all at the same time while trying to adhere to their core calling, which is to be a light and reach people for the kingdom, as they say, as we say. All right, another challenge in 2024 that my clients have been dealing with is declining attendance. For any number of reasons, there's been a lot of studies that have been done by really smart people. What's going on? So we have this trend. The Internal Revenue Code, again, this is part of the tax exempt status that churches enjoy. If you're tax exempt, you care about that. The tax exemption says that upon dissolution, a tax exempt entity must convey its assets to another tax exempt entity. So if a church has declining attendance and has made the difficult decision to close up and end on a particular date, let's just pick one. Church has declining attendance and has made the decision that as of 12/31/24, let's just say you made this decision back in the summer, we're going to be done. Then upon that date, the date of dissolution, that's a word we use in corporate law, we're going to dissolve the corporate entity. Then all of the assets, real property, personal property, the copy machines, the chairs, the pews, the AV equipment, everything has to be conveyed to another tax exempt entity. For churches in denominations, often the dissolution is as straightforward as, all right, we'll convey the real property and the personal property to the denomination. And the denomination will hold the assets as denominational assets, and the denomination will figure out what to do with it and hold all of the property as a denominational asset until the denomination decides what to do with it. And that's a somewhat common solution. Alternately, for a non-denominational church or an independent church that just got started and has had declining enrollment, the church needs to find a dissolution partner, perhaps a merger partner, or someone to take on the assets. It could be another church, it could be a charity, it could be anything of that type, but typically another church. There are very few churches that cannot find a dissolution partner to take on the assets. It's almost impossible to imagine that it would be impossible to find a dissolution partner. We've had a few cases where churches struggled until they called me and we figured it out within a very short order. It's usually not a problem. There's plenty of dissolution partners. I'm saying dissolution partner. You could easily use the synonym merger partner. There's plenty of partners to take on assets in this scenario. It's not difficult. A land transaction is easy. There's a deed. In a personal property transaction, there's a bill of sale. But these are simple, straightforward transactional documents. Confronting the end can be difficult. For some people, there could be a sense of failure, and church leaders and lay leaders sometimes have trouble getting to that point. I'm a lawyer, uh, not a counselor, a personal counselor, of course, we're counselors in the law, but I've seen this happen where confronting the end has its own challenge for people, but um, the legal issues are not difficult. All right, there is a complex real estate environment that we're seeing in 2024. Some of the real estate transactions that we're doing for churches here at the Carpenter Law Firm have had their own set of own set of challenges. Give you a couple of examples. Sellers are becoming more demanding. You say, well, why would a seller become more demanding? Aren't they just selling land for an amount of money? How can a seller become demanding? Well, a seller might want more flexibility regarding adjacent land they are not selling. We've seen some strange requests recently where the seller might own 100 acres and they're selling off 10. And then after the transaction closes, the seller may want the buyer to give back concessions regarding future development of the land that they're not selling. Buyers have to be flexible with sellers who want buyers to remain involved in the land that's not being sold. Buyers have to remain flexible. Sellers may want leasebacks. These are not complicated conceptually on a whiteboard, but there's nuance in the details of how these land deals are structured. Church school transactions are always more complicated than they seem. Land leases are complicated. I have a client that did a 99-year land lease, and it's extremely complicated. And you can't do a 99-year land lease and then 15 years into it and say, oh my gosh, what did we do? This is complicated. I regret it. That's a difficult thing to confront when a church owns a bunch of property and then leases all of it on a 99-year land lease, thinking, well, we'll just lease it back on a sublease. That's complicated. It's got to be lawyered properly from the beginning. So these real estate transactions, and it sounds like I'm lobbying for work, but complicated transactions need to be properly transacted from the beginning. And oh, the broker will handle it. Oh, well, we've got someone who's done a lot of these deals before in our congregation. Complicated real estate transactions need to be properly documented. It's saying to yourself, well, this isn't that complicated. Well, sometimes they are more complicated than they appear. So that's the 2024 year in review. What are we looking at in 2025 from a legislative standpoint? What has Congress got in store for us at the federal level, and what do we think we might see from the Arizona legislature? Well, Congress, we don't expect a whole lot. Remember, at the federal level, we have what we need in the Constitution. We have the free exercise of religion, and we have the separation of church and state. Now, some people say, well, the separation of church and state, that's what the atheists want. And, they want the separation of church and state. And then I think, well, that's what we want too. We want the government to stay out of our churches. We want the separation of church and state. and we want the free exercise of religion. For church folk who say, we want the government to um, endorse a Judeo-Christian perspective of religion, today that's what we want, but tomorrow all of a sudden the government is endorsing a different religious perspective. Now we sound like Christian nationalists. That's not right. Churches should want, and we need, separation of church and state. The atheists want that. Christians and churches want and need that. And churches want and need the free exercise of religion. So we have what we need in the US Constitution. From a legislative standpoint, nothing's really on the horizon, although there is some talk that there might be a bill to support discriminated religious minority people around the world, such as the Uyghurs in China. This is kind of a demonstration of support. It might be tied to some sanction on China, but it doesn't really mean anything to churches in Arizona or in America in general. But it would be more of a signal than anything else. In Arizona, there's not much that's expected. The Arizona legislature generally legislates by anecdote. If there's something in the news or something that's happened, or if people complain to their legislators, then they generally act. That's how our citizen legislature acts in Arizona. And there hasn't been a whole lot, although there was a pretty significant story of abuse in an LDS environment in southern Arizona over the last several years under the duty to report statute. But we could, in theory, if churches were to work together to lobby the legislature, there is some challenges under the duty to report statute and whether it's functioning appropriately for clergy. There's been some trouble over the years with our statutory rape statute. There's been this issue that there are, by any number of versions of how you look at this, what appear to be consensual teenage romantic relationships that are technically statutory rape. Now, set aside for the moment your perspective on premarital sexual relations. Consensual romantic relationships between a 19-year-old and a 17-year-old. What would be considered to be a normal, by our society, a normal teenage romantic relationship. This is statutory rape under Arizona's definition of sexual assault and statutory and rape. That triggers a mandatory duty to report by clergy if the clergy has a reasonable belief that this occurred. Now, we could debate for longer than I have left in this presentation how the clergy comes to this reasonable belief that it occurred. Is it a confession? Is it the parent of the girl? Is it the parent of the boy? How did it happen? How did the clergy come to this reasonable belief that it occurred? All kinds of challenges here as to the threshold as to how the clergy came to this reasonable belief that triggers the mandatory duty to report. But the real problem is not with the duty to report as it is with whether that should continue to be statutory rape. you get all kinds of different perspectives about consensual romantic relationships among teenagers. And uh, once that's rape, once we've wrestled with that as a society, as a state, as a government, what's the duty to report? And it's not just churches, it's school counselors, it's teachers, it's anyone else who has a duty to report that feels the same sense of obligation, that when a person sits in a uh, environment where someone has a duty to report and says, well, my girlfriend and my boyfriend, and we were involved with each other, and all of a sudden there's a mandatory duty to report. Um, these are some of the issues that become challenging. But until a mandatory reporter gets arrested for not reporting a consensual romantic relationship between teenagers, it doesn't get into the headlines. Uh, and some church people struggle with this because um, some church people uh, in some denominations and uh, some different perspectives are not as troubled by premarital sexual relations as others. And so this idea that there would be this mandatory duty to report an apparent consensual romantic relationship between teenagers is very troubling. So we're not, I'm not predicting that 2025, the Arizona legislature is going to do anything about this, but it's a reminder that Arizona's duty to report statute is is quite strict, and the duty to report is still there, and that statutory rape is a crime, and that teenagers are not particularly aware of the strict requirements um, of what they think is a consensual romantic relationship, but is actually statutory rape. I'm not sure that they're given training in their high schools about age gaps and statutory rape. All right, I have time for some questions. We take questions in this webinar format in in a written format, typed format, I should say. Somewhere up in the Zoom bar here. If not, it's been a pleasure providing these seminars this year. All of them will be available at our website at www, my goodness, carpenter.law. And it's been a pleasure. If there's anything we could do here at the Carpenter Law Firm, feel free to reach out. We're always here and willing to help. Thanks for joining us today. And if there's ever anything we can do,